This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviat. Tonight we're taking your calls and questions about slips, trips, and falls. So any kind of injury question we can answer tonight, but particularly things that happen when you fall at a store or slip at a restaurant or even at somebody's home. If somebody else failed to do something, failed to fix something, or failed to warn you about something they should have, you may have a claim. You may have a lawsuit. How do you know whether to go see a lawyer about that? Call in your questions. The 31 Law Call number 256-536-0077. You can also email a question. You can email a question any day of the week on any legal subject. And when we get to a show that's on point, we'll pull some out. We'll have some of your email questions tonight. You send them to lawcall@waaytv.com. Getting us started tonight, Michael Timberlake's here from Timberlake & Leak. Good to have you here.
Good to be here.
Happy Thanksgiving.
Yeah, absolutely.
We're getting started tonight with our You Make the Law Call. This is video. We found this one off of YouTube. Let's show you some video and you decide, okay, you're driving along. Everybody's been out traveling a good bit this weekend. You got to be watching for unexpected hazards. So something's going to happen here. What is that? Where did that come from? And it doesn't stop. So a big tire comes out of nowhere. We don't know if it's coming off another vehicle. How do you prove, obviously, this driver didn't cause it and they've got damage to their car? Is that a lawsuit? And how do you prove something like that? Michael, you guys get cases, unusual cases. We say that's 1,000,001 chance, but that happens, something happens that's 1,000,001 odds all the time.
Well, you know, obviously you got a couple of things going on here. Well, you know, obviously if you're going to operate a motor vehicle on the roadway, you've got an obligation to make sure your vehicle's in a safe condition so that if this was something that you knew or should have known that your vehicle was going to fail like this, then you could be potentially responsible for the damages caused by, you know, your wheel coming off. If you just taking your car to have the shop to have the tires rotated or something and the wheel falls off, then that's another potentially responsible person. We've had that case before. And then if you can't, and that's assuming you can track that person down, but if you can't track the person down, you can still make a claim on your own insurance, typically for underinsured or uninsured motorist coverage for a phantom vehicle, for you know, a foreign object in the roadway. If something falls off a car that would, you know, comes under your own insurance, even though it's somebody else's vehicle. And we've had a case involving a ladder. We've had a case involving concrete blocks. So there's ways to make claims out of this situation.
Okay. And answering questions with you tonight, you brought a partner with you who's actually had this experience,
well,
right?
He's an expert in this type of situation.
This one, for sure.
And he's probably going to critique me and tell me what I said wrong. But Heath Brooks is here tonight to talk about this.
Now, Heath, this happened to you.
Yep, spot on, driving down 65, on my way to Huntsville back in the day. Tire bouncing down the road, came off a truck, hit me on the right side of my car. Thought it was goodbye, cruel world. But, you know, I did make a claim against my insurance company. This is before I was a lawyer. In fact, I made a claim against my insurance company for a phantom motorist, and damages were paid, you know, for the property damage. Well, we see them all the time, ladders especially. I don't know what happens. Ladders falling off the work trucks, a lot of work around Huntsville.
Yeah.
Watch out for ladders on the roadway. They're all over the place.
Absolutely.
Okay. And you guys do these kind of cases, but you also do some civic-minded things too. You've got something special that happened over the weekend, and we wanted to brag on you and show off the crowd that you got for this weekend.
Yeah, every now and then we have a little bit of fun, and this is the World Cup comes around once every 4 years, and so we decided that we were going to block the streets off in front of our office and invite all our friends to come out, and we think this is the largest soccer viewing party in Huntsville history, and we had all of our friends out Saturday for USA versus England, and they held their own. It was a draw, but they held their own, and we can beat Iran on Tuesday, then we advance. So this is a huge crowd for Huntsville. We really enjoyed it.
Right outside y'all's offices. Fantastic. Good, good, good. Okay, we're taking calls and questions tonight, all about slips, trips, and falls. We've got some information here about when it's somebody else's responsibility, right? Some things that go into these kind of cases.
Sure. You know, I mean, first thing you got to have is you look towards, you know, why is that person on the premises? You know, and that's one of the things you look at is, you know, if you're there for a business purpose, if you're there for a social purpose, the obligation that the homeowner or the premises owner owes is a lot different, right, Heath?
That's right. You know, you can be what's called a licensee, meaning you're a friend of yours coming over to your house, or you can be an invitee. If you're going on to somebody else's property and you're going to provide a benefit, whether that's money or services or anything else, then that business owner, that premises owner, owes you a duty. And they have a duty to keep their premises in a reasonably safe condition and to warn you of hazards that they knew about, they should have known about, or they created. So basically, if you're walking into a convenience store or any other kind of large store and you're planning on buying something, you're going into a restaurant, those folks have a duty to keep their premises safe, to keep that restaurant safe, and if there is a hazard on the ground, water would be a great example of that, then they've got to warn you. They got to put a sign up, you know, so that you know that you can avoid that problem and not get injured.
Yeah. And, you know, one of the things we tell people in premises cases all the time is that simply because you're on somebody else's property and you get hurt doesn't make that property owner automatically liable for your injuries. You still have to show something they did wrong. You still have to show fault. And you also have to overcome some defenses. If it's an open and obvious hazard, if it's a pothole that's 4 feet deep and 4 feet in diameter, they're going to say that's open and obvious and anybody could have seen it and you shouldn't have fallen in it. So these cases can get difficult and they're not automatically, you know, somebody else's fault.
Okay, I think we've got Shirley on the line with a question. Hi, Shirley. Thanks for calling. What's your question tonight?
Okay, my question is, if you're in the hospital and you are awakened at 3 o'clock in the morning, you're 69 years old, and you're told you got to hurry, and you had surgery, plus you had you had like atrophy, and your legs aren't working properly, but you're told to hurry, and you're on a walker, and suddenly you just give way and fall, and you hurt yourself, and neither the nurse nor the two people that was telling you to hurry helps you in any way except by pulling your arms, and you can't let them pull your arms because you had surgery. And you hurt your leg. Didn't break it, but you're 69 years old. It swells. You're still having problems walking, and it's been over a month.
Shirley, is this you or is this a family member?
This is me.
All right. What can she do about this? In hospitals especially, we see things in nursing homes a lot too.
Right. Well, you know, you got to understand that every claim against a hospital or a physician or a doctor is not governed by the same law that other businesses are. These claims are governed by the Alabama Medical Liability Act, which provides special protection for hospitals and doctors in these situations. So instead of just proving that there was something on the floor, they did something, or that there was a hazard that they failed to warn about, you have to prove that from a medical perspective, they breached the standard of care, what they were supposed to be doing as doctors or nurses or hospitals, and that's what caused your fall. So it's a whole lot more fact intensive than just your normal slip and fall in water or slip and fall in a foreign subjects or the substance or a hazard in a parking lot or something like that. You have to kind of drill down into the medicine behind it. So you want to look at, okay, what did your doctor say? Did your doctor allow you to weight bear? Or did you need to have one person assist or two people assist? Were you supposed to be catheterized in the bed or offered a bedpan? What was your physical condition that they want to look at to determine whether you could ambulate independently or whether this was something that you needed assistance with? So it's really fact intensive in terms of that situation. You need to look at the medical records, order those from the hospital, look at those and then kind of see whether or not they did what they were supposed to do according to the medicine, the orders that are entered by the physical therapy people or the doctors at the hospital.
Heath, aren't there some things that, like at nursing homes, when you've got older folks that are slip risks, maybe they're labeled as that, right?
Yep.
And they're not being looked after. Does that change facts a little bit if it were in a nursing home instead?
you know, it really wouldn't, just because nursing homes are also governed by the Alabama Medical Liability Act. Of course, nursing homes, there are some federal laws that nursing homes have to follow as well. As you know, as some of the other state laws. So you'd still look at that fact-intensive medical record review to determine whether or not the nurses, the physical therapists, the occupational therapists, other medical practitioners violated the standard of care. In other words, did they treat that nursing home patient as any other medical practitioner would have treated that nursing home patient in the nation? And that's kind of your standard. You oftentimes have to have expert testimony to establish what that standard is, and whether or not that standard was actually violated by those medical practitioners or the nursing facility at the time. It'd be the same thing with the hospital. Was the standard of care violated? In other words, did those medical practitioners treat you in a manner in which other medical practitioners in that same circumstance wouldn't have treated you around the rest of the country? And you have to establish that standard with medical testimony and medical expert testimony, and also that's going to require a intensive review of your medical records.
So get the records.
Yeah.
Get the records and start with that. There might be something in there, surely, that would help you, and take it to a lawyer.
Right.
Okay, they're telling us to take a break. We're going to take a break, be right back answering more of your questions, all about slips, trips, and falls, and all kinds of injuries tonight.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Doviet, with the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Dovia. We've got with us Michael Timberlake and Heath Brooks, both from Timberlake and League, and we're answering questions about slips, trips, and falls, all kinds of injury cases, but especially slip, trip, and fall cases, and we've got callers waiting. B is on the line with a question from Russellville. Hi, B. Thanks for calling. What's your question tonight?
Well, I was wondering, I had to go to the...
That's okay. Yes, ma'am. Go ahead.
Oh, okay. I had to go to the doctor's office, and I kept my husband was with me, and he was on a cane, and he slipped and fell. So he's 84 years old, and I was just wondering.
Oh, wow. And he was on a what when he slipped, did you say?
Oh, he was walking with a cane.
With a cane, okay.
With a cane.
With a cane.
And he slipped, and he fell, and he busted his head. But they did come out and check him, and he was bleeding so much because he was on blood
thinners. Yeah,
right.
Do you know what he slipped on?
When we was going around the little curve thing, he slipped, and it fell and busted his head and his knee.
Okay.
Right. You know, kind of one of the main things we look for in this situation is what was the cause of the fall. Because just because you were there doesn't mean that they're automatically at fault. So a lot of times we tell people, look, if you can get me a picture of what you slipped on or something, or the area where you fell, it can give me a whole lot more insight into whether I think I can help you. And sometimes it doesn't have to be a hazard. It can be just a substance or an area that should have been treated differently, right, Heath?
That's right. And that's why I was asking you what caused the fall. And like Michael said, that's one of the pivotal things we got to look at to see if we can make a claim. And a lot of times, again, it's fact specific. But if you're dealing with curbs, or you're dealing with sidewalks, or you're dealing with step downs, or you're dealing with the entrances to buildings, a lot of times there are statutes that help guide those businesses on how they should treat those entrances and those curbs. In other words, if you have a step up, that step up has to be marked with a yellow paint line so that it can alert customers like your husband or folks who are going into businesses that, hey, look, there's a step up here. Otherwise, that's against code. And so we can make a claim and say, look, you violated code. So it's really critically important to make a determination about whether or not what you tripped on really conformed with what the law says it should have conformed with.
Okay, and we've got some graphics here that I think kind of walk us through some differences. Is it the graphics about the business property owner? Talk to us about that, Michael. Business property owner is liable if what? What would make them more liable?
Well, so business property owner, the people that come onto their property are legally classified as what we call invitees, and they are liable if they cause or they create an unsafe condition, a hazard on their property that results in an injury, or if there's a condition that somebody else created but they knew about it or they should have known about it. You know, we always talk about, you know, the most common thing is some type of water or some type of spill in a store. If the property owner didn't know about it and could not know about it, then it's not their fault. But if it's been there for some time or it's something they should have known about, then you can say that they ignored it. And if they ignore it, then they can be held responsible in that situation. So it's really a different situation from a business property to just a normal person that's you invite over to your house.
Okay, Heath, take part two. So they're not liable if what?
You know, here's one thing. If the condition is open and obvious, meaning if it is if there's a big box in the middle of an aisle in a store and you fall over that box, then you're not going to be able to hold that store responsible. And that goes in concert with using a reasonable care to avoid that big box sitting in the middle of the hallway or the aisle. But one thing that's critically important in these types of claims when you're dealing with these concepts of, did the business owner know about the hazard? Did they know about the water in the floor? Did they know about the tripping hazard? We have to prove that. In other words, you as a plaintiff, we have the burden to prove that if we get in front of a jury or if we get in front of a judge. So that evidence oftentimes is the video camera footage from the actual store where the incident occurred. And a lot of times that video footage gets rolled over every 30 days. Different businesses have different policies and procedures of how they retain that evidence. And evidence is like water. It evaporates. So if you do have a fall in a store or on a business, it is critically important for you to get in touch with somebody, particularly if you have a serious injury, so that we can take the steps necessary to maintain that video evidence. Because once it's gone, it's gone. You can't get it back, and then we can't prove that the business owner had notice of that water or had notice of that tripping hazard. So it's critically important to try to retain that evidence.
Okay. You guys have had some hotel cases, right? That tends to be more common than I realized. Hotel slip and falls.
Well, you know, the common areas in a hotel can be in the lobby area or within the room itself. But there's standards for coefficient of frictions or types of devices that need to be in place in hotels in terms of to try to prevent people from slipping and causing injury, especially in areas that you're known to be wet, bathrooms type things like that. Showers, anti-slip materials in the bottom of a bathtub, very important things that you would look at. So there's lots of different standards that we can look at for particular usage in a hotel or motel that can help us try to prove a case.
And those injuries can be, they can be pretty bad sometimes, right? Oh, yeah. Heath, you guys don't tell us the harsh ones, but there can be some really dangerous things happening.
Yeah, we've had some terrible injuries in bathrooms, in particular in hotels, gruesome types of things. You walk into a hotel bathroom, you think that, it's in good condition, it's just been cleaned, and what you don't know is maybe there was some spray that was sprayed in there that was left on the floor, creates an ultra slick condition, and then you slip and you fall and you hit your head on the side of a toilet. We've had that happen, hit your head on the side of the bathtub. And a lot of times in those types of circumstances, when we talk about coefficient of friction, what we mean is how slippery is the floor. And there are ways that you can test a floor to see how slippery that floor is. And oftentimes we have to hire an expert to come in to do those tests so that we can go back to the hotel's insurance company or the hotel and say, hey, look, you violated these standards. Your floors were too slick. My people didn't know anything about it. And now you're responsible for these terrible injuries. And that's a recurring theme, but it does require you to gather the evidence, to keep the evidence secure and to hire the experts necessary to prove your case.
Okay,
Yeah.
now that sounds expensive to do a case like that, though. If I'm injured, I don't have money for paying for an expert.
Right, right. And you know, so the one thing is you need to talk to a lawyer about it as quickly as possible so that you can make sure that they maintain the evidence and that they don't, change something in the room. But we also, what we do is we work on a contingency fee basis on these cases, so we don't ask for any money up front. And we'll investigate the case, and if we think that it's a case that's worth spending money on to hire an expert to come up and look at the situation, we do that. We advance that cost. And at the end, if there's no recovery, then that's something that we're responsible for. We don't get that back from our clients if we can't make the case. We just move on to the next one.
Okay, we got this email question. This one's kind of long and complicated, but here we go. I fell down the stairs at my apartment complex. The concrete stair broke due to the base being metal and it rusted away. I fell. I tore my tendon in my left elbow. I injured my back as well. I'm in a cast for 6 to 8 weeks. I'm left-handed and this is screwing up my life. Do I have a case? The insurance company contacted me. First off, should he talk to him? And do I need an attorney? This is from RG.
Yeah, I think we've had this case, right, Heath?
I have it right now. You see these in apartment complexes where the concrete has been filled into a mold, into a steel mold, and then the steel over time, of course, it rusts, it becomes brittle, and then it breaks. And the reality is that yes, in that kind of scenario, you do have a case to make because that is the fixture on a piece of property. And under Alabama law, if it is a fixture, in other words, if it is a toilet, if it's a stairway, if it's something that stays with the property, then the landlord in that scenario is responsible for its repair. But it could be the property manager that bricked it, or it could be somebody that came out there that tried to repair the stair that was paid for by the landowner. So there could be other defendants, but yes, you need to contact a lawyer. No, you do not need to talk to an insurance company. You most likely have a claim there.
Okay. Yeah, you don't need to talk to an insurance company in a premises case without talking to a lawyer first.
They're trying to get you to say certain things, right?
Yeah, absolutely.
Maybe. Okay. We're going to take a break. Be right back answering more of your questions, all about slips, trips, and falls. Stay with us. If you didn't get your questions answered tonight, here's how to get in touch with Michael Timberlake and Heath Brooks. They are with Timberlake & League in Huntsville, personal injury attorneys, so that's everything from car accidents to medical malpractice, nursing home negligence, 256-536-0770 or 800-804-2502. The website is law-injury.com, and if you like them on Facebook, you can learn more about the law that way. Also, check them out tomorrow, Monday, on WAAY 31 Midday News at 11 o'clock. I practice family law, divorce, child custody in Huntsville, 256-539-7337. Also check out SharonFamilyLaw.com. Next week, we are going to be talking all about workers' compensation. Thanks for all your questions tonight. Good job in answers.
Have a great night.
Good night.